All right, so when you think about international justice, what comes to mind? Probably these huge, dramatic courtroom showdowns, right? Well, today, we're going to look at a case where the real battle wasn't fought with big speeches, but with a quiet, strategic series of letters. We're pulling back the curtain on the Ambatielos case to see how a massive conflict between two countries unfolded, one piece of paper at a time. It's a real procedural thriller.
And it all starts right here. This is the letter. It might not look like much, but this single document from the International Court of Justice is the first shot fired. It confirms that the government of Greece has just officially filed a case against the United Kingdom. And believe me, this one letter kicks off a legal battle that's going to last for years.
So, let's get into it. First up, Greece sues the UK. We're going to see just how a dispute over one single shipowner's claim managed to climb all the way to the world's highest court. So the date is April 9th, 1951. This is the day Greece makes it official and starts the legal process against the UK. And what's at the heart of all this? It's not a border dispute or anything like that. It's a fight over the claims of one single Greek shipowner, a guy named Nicolas Ambatielos. Just like that, a private business problem has exploded into a full-blown showdown between two major nations. Okay, so less than a month goes by and the UK fires back. But here's where it gets really interesting. They don't argue about the shipowner or the money. No, instead they go right for the jugular. They basically say, we're going to fight whether this court even has the right to hear this case. It's a brilliant strategic move. I mean, why bother arguing the details of the case if you can just convince the judge they have no business being there in the first place?
And now we get to what I like to call the procedural dance. The battle lines are drawn, and both sides start making these careful, strategic opening moves. This part isn't about moving fast. It's all about positioning. Every single letter, every request is like a calculated move in a really high-stakes chess match.
So the court kicks things off by asking for two really important documents. First, Greece has to submit what's called a memorial. You can just think of this as their opening statement. It's where they lay out their entire case, all the arguments, all the evidence, everything. And then, once that's in, the UK gets to fire back with their counter-memorial, which is their formal point-by-point takedown of Greece's claims.
Now, the court sets deadlines for these documents, but, well, they don't really stick. You see this pattern emerge. In July, Greece asks for another month. Then in October, the UK asks for 2 more months. Then they ask for another month in January. Every single one of these formal requests just resets the clock. It's a deliberate strategy to push the real face-to-face confrontation as far down the road as possible.
Okay, so after all those months of back and forth, all those strategic delays, the United Kingdom finally shows its cards. And this is the UK's big move. It's a total plot twist that completely changes the direction of the case. So, imagine this. What if you could fight a lawsuit, not by arguing you're innocent, but by arguing the court has absolutely no power to judge you in the first place? That is the core of the UK's strategy. It is such a bold move. They're not defending what happened with the shipowner. They're attacking the court's authority. They're essentially putting the court itself on trial.
And you can see it right here, buried in another letter asking for more time. The UK's agent slips in this absolutely critical line. They signal their plan to file a preliminary objection to the jurisdiction of the court. This is it. This is the first formal hint that they aren't just going to play defense. They're going on the attack, targeting the court's fundamental authority to even hear this case.
So, let's break that down. What exactly is a preliminary objection? Well, it's a super powerful legal move. It's not about arguing whether you're innocent or guilty. It's basically you telling the court, hey, you don't even have the authority to hear this case. It's a direct challenge to their power, and if it works, it can stop the entire case dead in its tracks before you ever have to argue the facts. And then, on February 9th, the UK makes it official. They file the paperwork, and boom, instantly the entire case about the shipowner gets put on ice. All proceedings are suspended. The original fight is over for now, and a brand new, much more fundamental battle has just begun. A battle over the court's very power.
All right, next section. Lawyers and judges assemble. Because now the fight isn't about ships anymore. It's about jurisdiction. The whole game has changed. Both sides know this is a whole new kind of battle, a huge confrontation about the court's authority. So you know what that means. It's time to call in the heavy hitters.
Now here's a really fascinating part of the process.
The court's rules actually allow Greece to appoint its own judge to sit on the bench for this specific case. It's called a juge ad hoc. So they picked this guy, Professor Jean Spyropoulos. And what's wild is that when the UK is asked if they have a problem with it, they formally reply that the choice is welcome. Just like that, the bench is set.
And it's just a small detail, but it's worth remembering that this entire global chess match is happening in 2 languages at once. Every single application, every letter, every order, it's all meticulously done in both English and French. It's a great reminder of just how formal and truly international this whole thing is.
So both sides start building their legal dream teams. You can see the names here, absolute powerhouses of the law. But look at Team Greece. They make this absolutely stunning move. They hire Sir Hartley Shawcross. Now, this isn't just some big-shot lawyer. This guy was the former Attorney General of the United Kingdom. Let that sink in. Greece hired the British government's own former top lawyer to argue against the British government. You just can't make this stuff up.
Okay, so now the stage is set. After almost a year of all those letters, all the delays, and all the legal maneuvering, this battle of paper is about to reach its first real climax. A direct confrontation is finally coming.
And on April 4th, 1952, right on schedule this time, Greece files its big response. This is their formal counter-argument to the UK's challenge about jurisdiction. And with that single document, the paper battle is officially over. The court has all the written arguments from both sides, and now it has everything it needs to move on to the next and much more decisive phase.
And here it is. After more than a year of sending letters back and forth, it all comes down to this one date, May 15th, 1952. The president of the court sets the date for the oral hearings. The lawyers are finally going to meet in person in the same room to argue one single question. Does this court actually have the power to judge this case?
So the paper battle is over, but you know what? The real fight is just about to begin. After a whole year of this procedural warfare fought entirely through the mail, the stage is finally set. The original claim about the shipowner is almost a distant memory, replaced by this way more profound legal drama. And it leaves us with a question that really cuts to the very heart of international law. What happens when a court's first job is to judge its own power?